advice, as well as corporate finance services. His expertise is in valuations and financial analysis, and it is often sought as an independent expert for disputes in commercial law and family law matters, in particular shareholder oppression and compulsory acquisition matters. Our other speakers are Chaplin-Burch from Aitken Partners. Dylan is a family law lawyer and offers advice about property, children, and family violence matters. He has a special focus on complex property matters and enjoys dealing with family companies and trusts associated with the relationship. Dylan also works directly with matters involving family violence and intervention orders in the magistrates' court. Finally, we have Natasha Ozolins from Aitken Partners. Natasha is a compulsory acquisitions lawyer and acts on behalf of landowners, businesses, and tenants in compulsory acquisition claims and disputes. Natasha's focus is to ensure that clients affected by compulsory acquisitions are made aware of all of their rights and to ensure that the clients obtain all the compensation to which they are entitled, financial or otherwise, in a low-stress environment. I've been asked to speak briefly about valuations from my perspective. What I have to say falls into three parts. Firstly, valuations for damages and oppression claims. Valuations are often called for to justify or attack claims for damages. The things that can be compensated for by awards of damages are the subject of long and prolix judgments by courts that set principles for the award of damages. But after a trial, when there's been a finding of liability, the trial judge can either order an inquiry into damages by another judge or award an amount of money to be paid by way of damages. Similarly, in oppression cases, the court may order one party or the other to buy out the shares of the other party. Some formula must be found to fix the price if the parties have not set their own rules in a shareholders' agreement. Where the property for which compensation is being paid is land or company shares or some other financial investment or a trading business, the judge who has to decide the amount will usually be reliant on valuers to estimate the range into which the valuation should fall. Back in 1999-2000, I acted for a company of fitted furniture manufacturers. They owned a factory in the UK that operated successfully, if in a labour-intensive way, using a range of standalone machines dating back to the 1930s and making a net profit of around £1 million per annum. That's $2 million equivalent. They had seen a computer-controlled continuous process line that would replace all of the old but reliable machines installed in their factory. With this line, sheets of MDF, medium density fiberboard, were fed in at the beginning of the line, and designs for a series of disparate components for kitchen cupboards and other such furniture input via the computer terminal. Theoretically, the finished components could be collected at the end of the line without human intervention. The company only had space in its factory for one line, so it did a deal with the manufacturers to acquire a new line, fitted, installed, and fully working, turnkey, as you might say, in exchange for all its old machines and a substantial cash sum. The factory had a longer than usual summer break and came back to the new line, which unhappily never ran continuously for more than half a day without serious breakdowns. How was the court to decide how much to award for damages? Our valuers said that companies in that industry sector usually sold for 3 to 4 times the amount of their earnings before tax. The old machinery had a second-hand value, and the company owned the freehold of the factory, which could be sold after the new line was decommissioned. Putting all that together came to a valuation of just under £5 million, say $10 million. What actually happened then was an object lesson to me in the value of such valuation reports. I received a phone call from my client to say that he had settled the claim for £2 million, say $4 million, payable by installments over 12 months. I was sure that the court would have awarded him much more and tried unsuccessfully to persuade him not to settle. Didn't I feel foolish when, after paying all the installments of damages, the defendant itself became insolvent and was wound up? So, if those same circumstances occurred under COVID-19, what advice should we give? And the answer is probably very little and in a cautious way. This is because, like the insolvency in my example, COVID-19 would have had a profound effect on the claim, in the case of COVID-19, by causing a sudden downturn in activity, which might make the valuation multiple lower than 3 to 4 times earnings. But COVID-19 is not necessarily a one-off event like insolvency of the paying party. What about if the business itself became the center of a new outbreak, or there was a second wave of COVID-19, which I know we all fear, or if the virus itself changes so that it resists the vaccines that are being developed or becomes airborne? Such things might result in a return to lockdown with a national treasury unable to support job keepers and job seekers' allowances, despite finding an unused 60 billion in the national coffers. Expert valuers, as my client in the example realized, can only take snapshot pictures. We should always ask, what is the effective date of the valuation? And then consider what might happen to change that. My client, in the example I gave, was given a £5 million, $10 million snapshot. But he realized, as I later found by looking into the defendant's affairs, that they might become insolvent, and they did. What should we take away from this in relation to valuations used for damages purposes? Firstly, we have to make sure that any orders for valuation specify the effective date for the valuation, because by doing that, we can try to choose the date most suitable for either the paying or the receiving party, depending on who we're acting for. Secondly, I'm now acutely aware that we should always allow for the solvency of the other party, especially in a world beset by COVID-19 uncertainty. And thirdly, the most obvious thing that we can do is, if we've got a good snapshot and a paying party that hasn't folded up, we should consider whether security and guarantees from third parties may assist us if any part of the payment is deferred. The second aspect that I've been asked, or that I've decided to look at, is general business issues around valuations in the present climate when buying or selling. And whether you're dealing in land or business property, the main issue of concern is the sustainability of the valuation. In addition to the normal due diligence that we always undertake and have always undertaken pre-COVID-19, we need to consider whether the value of the property will hold up through the current outbreak. And I've heard banks and valuers suggest that there may be anything between a 10 to 30% fall in values for land. I have very little faith in these predictions. The owner of a Toorak mansion who can wait out the effects of a depression will suffer much less than one who's forced by his lenders to sell immediately. The second issue might be whether the value of the property will survive the subsequent outbreaks. In insolvency terms, the courts have told us that directors may be justified in trading if they can see light at the end of the tunnel. any decision whether to buy or sell an asset will start from the valuation snapshot, but after that must take into account a view of the future. Those COVID-19 variables, which I mentioned before, are important, but again, we must not let the COVID-19 tail wag the economic dog. Also, that analysis which says that the PE ratio, the price earnings ratio, is 3 to 4 times profit before tax, and in my previous example, will be profoundly affected by the length and strength of an economic depression. The other main issue is whether the market that set the predicted value will ever recover from a depression. If the current wisdom is that the share market is largely supported by super funds, and if there are progressive releases of super to enable people to fund their living expenses, as there must be when JobKeeper and JobSeeker funds are exhausted and no more can be borrowed by the government, these investors may disappear from the market temporarily or even permanently. We may have to adjust to a new reality in valuation terms. My third topic is the effect of COVID-19 on lending, either business lending or private lending, mainly for the small to medium-sized entities, which we call SMEs. Business funding comes from the banks, and fundraising by SMEs from the stock market is possible but uncommon. The banks will always act in their best interests to enhance shareholder value. Because of valuers' potential future liability, valuations for lending will be conservative, and banks will add their own perspective to the valuation. I recently advised a managed investment scheme which held a portfolio of motels with significant revenues that was probably worth $40 million and was subject to borrowings of $25 million. Not an uncomfortable LVR, you might say. The lending bank, which had encouraged my client over a period of 20 years to put all its loans in one basket, in other words, with that one bank, brought in a new, very conservative valuer who decided that the motels were only worth $20 million. The lending bank then decided it wanted a higher revenue to interest cover, a lower LVR, and would in future disregard the value of businesses under management, that is, those motels where the operator had defaulted. Throw in a couple of tenant defaults and some of the investors began to call for a winding up. It was only because one of the investors was able to provide the scheme with security for its borrowings of a further $10 million against unencumbered assets that the bank could be placated and dismiss their very expensive advisors, and the scheme was then allowed to continue to trade on normal terms. And what a surprise, the valuations pre-COVID-19, though not back to 40 million, came to well exceed borrowings. In my opinion, the scheme would not have survived such an attack by the bank under COVID-19 conditions, and anyone thinking of using borrowed funds for acquisition needs to accept that the valuation for lending will be on the conservative side, and as I've said so many times, it's only a snapshot. Even if you are satisfied with the snapshot valuation, the additional questions that fall to be asked by a purchaser is whether the purchase would survive the further COVID-19 variables that I discussed previously. And secondly, if the lending bank throws a wobbly, is there somebody that can help hold the line in financial terms until matters improve? Finally, if both things happen at the same time, would I be able to survive? On that happy note, I'll hand you over to Mark and Tony. Or at least I'll try to. Are you there, guys?
Thank you, Chris, and thank you everyone for having us today. So very exciting time to be a valuer. Andrew, have you got the slides ready to go? Yep. So last week, very interesting headline in The Age. Us valuers don't make the newspapers very often, but Mr. Bartholomew said that the pandemic has thrown out the textbook approach to valuing anything. And well, I'd like to rest assure everyone that is not the case. Things haven't changed that much. If you didn't notice this morning, the sun rose. I'm sure everyone had breakfast. Would have read the newspaper, 72% clearance at auction on the weekend. Last week, a business in the US raised $9.5 billion to buy IT businesses. The world economy is continuing, and if we go back to pre the virus, we still had to deal with issues of this year we lost Holden. Go back a couple of years, we lost Video Easy, Masters. We've had the rise of Instagram and Netflix as free-to-air TV has waned. Amazon's taking over everything. Toys R Us went bust a couple of years ago. The toy industry revenue, I think, dropped about 20% in one quarter, and then in the next quarter recovered as all the small retailers benefited very quickly from the demise of Toys R Us. So yes, things are uncertain. Maybe they're a little more uncertain, but that's what we deal with. Next slide, please, Andrew. So I've been asked to talk today on assessing the impact on business, dealing with risk and uncertainty, and preparing for evaluation. Next one, Andrew, thanks. So in terms of the impact on business, we've all seen firsthand retailers close everywhere. And very much in Australia, it's retail, the entertainment industry, and tourism. We see some big headline numbers that the ASX dropped 37%. It was wound back to where it was back in December 2011, and the GDP has dropped 10%. They're very broad numbers and don't help a lot from a valuation perspective because we're looking at a per company situation. Andrew, next slide, thanks. The US published some mind-blowing numbers a couple of weeks ago where they compared retail spending in the week ending 1st of April 2020 back to previous year. And all those red dots are the businesses that suffered. And you can see that movie theatres and airlines almost dropped 100% in that week. Fitness, apparel, fast food. Fast food is quite interesting that it dropped so much, but I guess that's because of the number of businesses that actually closed. Interesting, there are, or were in that week, a number of winners: supermarkets, general merchandise, alcohol, food delivery, gaming, and the streaming of absolutely everything has been a massive winner throughout the virus. Early reports from China, which has gone back to work before everyone else, is that consumers aren't spending. So that's a big warning sign for Australian retailers. Unilever has forecast that 15% of restaurants in China will be closed permanently by the end of the year, and 25% in Hong Kong. Don't want to harp on the bad news. Good news is governments have reacted very quickly because, of course, this has been not an economic crisis. This has been a medical crisis where the governments have made decisions and impacted the economy. So they've tried to prop the economy up with huge amounts of stimulus worldwide. The US, $3 trillion. Australia's federal government stimulus, 16% of GDP. So there are other forces at work. There are losers, there are winners, and the government are trying to help everyone on the journey. Next slide, please, Andrew. In terms of dealing with risk and uncertainty, The little fellow in the middle represents the valuer, and our head is in the gun all the time in trying to value the future. And we're surrounded by litigators, the ASX, barristers, judges, other accountants, other experts that are always reviewing our work. So in terms of dealing with risk and uncertainty, that is our environment that we're used to. Next slide, please. Valuation is very much a job of forming an opinion of the future and reducing that to a couple of numbers to quantify future uncertainties. And we always only have the past as fact, and the history can be very random, and at this point in time, history possibly means less for certain businesses than other businesses, because the future is going to be different. People are going to behave differently, whether that be a short-term or long-term. Economists are split on how long it will take the world to recover. If you go back to the GFC, Europe had what's called a W-shaped recovery. The US had a U-shaped / V-shaped recovery, and Australia sailed on through and didn't miss a beat. If you can remember back to our 27 periods of economic growth.
I think, can I step in?
Yeah.
I think it's also important to acknowledge that there is a difference between value and price. In the current economic crisis, people are focusing on price and the marketability of property, marketability of business. But when we're engaged to assess a valuation, we're looking at long term. So our view is not what the value of the business is based on the market tomorrow. I mean, we're not being engaged to assess what could be realised in the market if you put the business for sale tomorrow. We're being asked, what is the inherent value of the business, which takes a long-term view. So, if there is a U-shape or a V-shape recovery, then the impact on the value of the business will not be as significant as what people might think.
So when you're dealing with future uncertainty, the valuer obviously is always looking for evidence to support his claim. And yes, there may be less evidence than previously is the case, but the valuer will still be looking for evidence, and which partly leads into the next series of slides, preparing for valuation. Now, I understand that there might be quite a few participants that are caught up in compulsory acquisition or other types of disputes. If you want a high number for your valuation, essentially a valuation process is a mini sale of the business. And if you're going to sell your car, you would give it a good wash and prepare it in the best possible light. And the same goes for preparing for valuation. Unfortunately, we do see the opposite happen when people want a lower value, and businesses can go out of their way to do certain things to reduce the value, which our role is an independent expert. So we are there to test things, and we do see through some and know some of the tricks that people get up to. So just before we move on, two very important things is that people need to understand, if they haven't been exposed to valuation, is that value cannot be created retrospectively. So if you're going to enhance the value of your business, you need to do it now, not after the date. So when you do a valuation, you have a date of valuation, and even if we're doing a valuation, say in December 2020, if the valuation date is 30 June 2020, we don't have the benefit of hindsight. We have to look at the world as if we were standing there on the 30th of June 2020. So preparing for the valuation is really important. And when I say prepare, if you've got a long long time horizon, 1 or 2 years, then there are obviously lots of things you can do to improve your business. If you've only got a week or two, or even if we're doing a valuation retrospectively, some simple things which they might sound like not a big deal, but these things make a really big difference. Because when you present your business, you're essentially selling a story to us that we have to quantify. So have the history in order. All your compliance things need to be sorted and up to date. You need to understand your historical numbers to be able to tell us about what's going to happen in the future. Next slide, please. I guess too often we're in a situation where people don't really understand their history. I recall a recent valuation where the year before or 2 years earlier, the business's revenue had dropped 40% and the business was not aware of that. However, they had absolute clarity that the value of their business was going to go through the roof. So obviously, there's a huge credibility issue if you're in that type of situation. And given the very fast hit to the economy of the virus, forecast will be more important than it has historically been. And at the same time, we have to test those forecasts. So if you don't understand the history of your business, it's going to be hard to sell your forecast. Now, a lot of businesses don't historically do forecasts, so this could be a new process for them. So again, in terms of preparing for valuation, understand that we will be looking for forecasts, and our role as an independent expert is to essentially pre-vet your work and your forecasts before you go too far in a litigation situation. If you're in a compulsory acquisition situation, the government will have a valuer on their side that will be looking to tear your forecast to pieces. So our job is to ensure the numbers that are being put together make sense. In preparing, I guess, for some businesses that have been shut for a number of weeks, your strategy to get your business up and going again is going to be obviously really important. The businesses that are proactive and out there doing things now and can evidence that the things that they're doing are assisting in bringing customers back to their businesses, that's obviously going to help in terms of supporting forecasts, as opposed to the business that is not as proactive and hasn't done that much in terms of getting customers back. Then if they're looking at strong growth in their forecast, well, obviously that's a fair question mark. Well, how will you achieve these forecasts if you're not doing anything at the moment? So unfortunately, we've got limited time, and the conclusions, the most important things to understand is that valuation, preparing for valuation, will be looking for even more work than normal from the business being valued, particularly in terms of forecasts. And to prepare good forecasts, you need to have a really good understanding of your numbers historically and have that compliance up to date. There will be more analysis on our part to understand, do these forecasts make sense? And also it must be, all parties must understand, from the lawyers to the business owner, that the evidence that's out there, it's just going to be less. So, whilst we had 75% auction clearance rate on Saturday in terms of properties, the number of businesses sold, the number of properties that were sold is less, and that'll be the same in terms of business transactions. The actual number of business transactions is less. Historical transactions have less weight than they normally would because it's in the pre-COVID-19 environment. So everything's just a little bit more sensitive than it used to be, but generally, when it comes to valuation, things are very much the same. And sorry, Mr. Bartholomew, You're a good journalist, but when it comes to the valuation, things haven't changed. Don't throw out the book. Tony, have you got anything?
Well, I agree. You don't throw out the book. The methodologies that we apply are fundamental, and they've been in place for many years. And it's a matter of picking the right methodology, of selecting the right methodology for each situation. And in every economic cycle, there are winners and losers. And in this particular situation, that's no different. And we've got many businesses that are going gangbusters. We've got some businesses that are immune from the impact. And then we've got some businesses that are really struggling. And in some of those businesses, that struggle will be temporary. And in other cases, it'll be a fight for survival. So when we're applying our techniques, our valuation techniques, it's a matter of selecting the appropriate methodology for the circumstances that we're looking at. And it's very important that you understand that a broad brush approach won't be appropriate. And for that, that's why we apply our expertise to make sure that we're using the right tools on each situation.
Andrew, do you want me to answer the questions now, or leave those till later?
We'll answer the questions later on at the end of the session. So maybe if we just hand straight over to Natasha now, and we'll come back to the questions, because our experience is a whole file through over the next 5 minutes.
Yep.
All right, good morning, everyone. My name's Natasha Oslands, and I'm a senior associate practicing in our compulsory acquisition department at Aitken Partners. And I've been in this team for about 10 years. And I work with Andrew Blogg, who's one of the partners here. You probably know him, and one of our junior solicitors, Mark Manane. Some of the recent projects we've been working on in the compulsory acquisition space are the Healesville-Kooyarrup Road duplication, Bridge Inn Road duplication, Crogie-Burn Road duplication, and the North East Link project, which you've probably all heard about. And I'm proud to say that we only represent council claimants, and we don't act for any government departments or local councils, which some other law firms do, straddle both sides. And I think it's probably an opportune time for us to discuss the compulsory acquisition space and business valuations because of the North East Link project, which is about to kick off, and because there's about 100 businesses that are going to be affected by this particular project. And it's important to look at this with everything that's going on with the COVID-19 pandemic, because there's been delays to that project. So just by way of background, if you don't know anything about a compulsory acquisition, the Land Acquisition and Compensation Act is the legislation that is the framework for our space. And when a government department or council or acquiring authority, whoever it is, has done all of the planning that they need to undertake for the road or rail infrastructure that they will be constructing, they need to commence a compulsory acquisition process. So to start that process off, there is a notice of intention to acquire, which is the first formal notice, which puts the world on notice at large that there's going to be a partial or a full acquisition to a piece of land. The authority then needs to wait a minimum of 2 months to a maximum of 6 months before they serve what is called a notice of acquisition. And that's a notice that effectively transfers the land from the registered proprietor to the authority without the need to sign any paperwork. And it also terminates any lease arrangements that are on foot between the registered proprietor and the tenant or business owner that's operating from that site. So the next thing that happens is an offer of compensation, which comes about 2 weeks after the notice of acquisition. And then the claimant has a period of 3 months within which it gets together its expert advice to support its claim for compensation. And then it'll put in its response to offer, which is effectively its claim. The authority then has a period of 3 months within which it then responds to that offer. And at the end of that, or before that possibly, there's what is termed a valuers conference, which is like a mediation. It's a without prejudice conference to try and narrow the issues in dispute between the relevant experts. So it might be a business valuer or it might be a land valuer. So in this instance, we're having a chat about business valuations. So what does a business valuer do if they find out they're going to be affected by a compulsory acquisition? When a project is announced and someone finds out that they are going to be affected, it's really important that somebody obtains legal advice because they need to get that initial advice to find out whether or not they obviously have a right to claim compensation and whether or not they've got an interest in the property, and also whether or not their business records are up to scratch for them to be able to support a claim for compensation. And I think it's also a good time to get some initial advice from a business valuer to have a look at books and records to make sure that they're in a good order, because if they're not, it's going to inhibit any claims for compensation at a later stage. And getting this initial advice assists the business owner to be able to make a decision when their compulsory acquisition happens to determine whether they want to relocate their business or extinguish their business. So what happens when a compulsory acquisition actually happens and a business owner's land is acquired? So there's two options, as I just said. There's a relocation, and that's where the business owner will, in all likelihood, find an alternative site to relocate their business to, and then they'll commence operating at this new site. Or the other option is an extinguishment claim, and that's where a business is extinguished at the date of the notice of acquisition. And this can occur for a number of different reasons. The business owner may be close to retirement age, or there may be personal hardship reasons, or they can't find a property to relocate to for lots of different reasons. North East Link project is a good example because there's 100 businesses that are going to be affected by this project. So there's potential for a shortage of comparable properties. The rental market might have increased. They might be part of a franchise agreement and they can't relocate in the same area that they were, or they're just priced out of the market. So why do we get business valuations done in compulsory acquisition matters? The two main reasons are, in a relocation scenario, we get a business valuer to undertake a loss of profits assessment or a business interruption assessment. So when a business owner has relocated or is relocating, their focus is going to be on moving to the new site and setting up in the new site. So their time has been taken away from operating the business effectively. So we get a business valuer to come in and have a look at what's the loss of profit and the business interruption for the period of them closing the doors, relocating, and then re-establishing themselves at the new site. And the other reason that we get a business valuation undertaken is to evidence a business extinguishment. So what is the business worth at the date of acquisition for the purpose of determining their compensation? And the impact of COVID-19. Obviously, there's been significant impact on businesses, which has just been discussed by Mark and Tony. And this economic impacts have obviously been compared to the global financial crisis. However, the extent and speed of it's been unprecedented. As a result, we obviously expect to see that there's going to be some significant flow-on effects for valuations of businesses as we move on. And business valuations are an invaluable tool for compulsory acquisitions because they determine the appropriate value of compensation. And valuers are required to assess the value of the business at the date of the notice of acquisition in compulsory acquisition matters. And as a result of this, there is a possibility that there's going to be difficulties in assessing compensation. And this has come to light, particularly with the North East Link project, because there's been delays. So we were expecting notices to be served in March this year for the compulsory acquisition process to kick off. However, there's been delays for a number of different reasons as a result of COVID-19, and they're not going to be serving their notices until the end of June unless people opt in early. So that's obviously raised a flag with us that we don't want to be seeing the government capitalising on the COVID-19 pandemic and as a means to reducing claimants' compensation entitlements. In the current context, the application of traditional methodologies for valuations, such as a comparable sales for a land value or discounted cash flow methods for a business valuation, may be difficult, even when there is some certainty arising from government intervention, which is the notice of acquisition. So we all have a certain date. There is existing case law However, that supports that the task of a valuer in assessing market value, at least for land purposes, should not be impacted by abnormalities in market conditions, as what is required to assess a land value for market value is a hypothetical sale between a willing but not anxious vendor and purchaser. And this was seen in a Brisbane Water County Council and Commissioner of Stamp Duties, which is a New South Wales decision. This may be of assistance when valuing a business. However, it's uncertain whether COVID-19 would be considered by the courts as abnormal, given there's no clear end in sight. If COVID-19 doesn't meet the definition of abnormal, there is further case law to suggest that courts will accept that unusual circumstances which continue for some period of time that may disrupt the operation or activity of a business and influence valuations could be considered. And in this regard, there was a decision of Elders Trustee and Executor Co Limited and Higgins in 1963, which could be of assistance. And in this case, there was a trustee which continued carrying on a grazing business on a property after the death of the grazier, and he failed to exercise an option to purchase the property or a portion of the property, which is an asset of the business. And in those circumstances, the court decided that the relevant event which was impacting the business and was termed the unusual circumstances was World War II. So practically speaking, valuers may be asked to value a business maybe pre-COVID and post-COVID with a limited scope to the current economic context. And valuers may also be asked to consider the ongoing impact of the pandemic in their cash flow calculations. This may assist businesses in establishing the true value of their business and the value of the business following the easing of these government restrictions. It's also possible that alternative methods of valuation may be utilised in the current circumstances, but obviously that's largely a decision of the expert valuers, which is what Mark and Tony were saying before. Nonetheless, although there are clear principles to guide valuers in making their valuations, and there's some guidance from the courts as to how valuers should deal with abnormal or unusual circumstances, the COVID-19 economic context is highly unique, and it's uncertain how precisely it's going to impact the value of businesses into the future. Accordingly, it's really crucial that businesses respond to the impacts of COVID-19 to navigate the current and foreseeable issues that have arisen as a result of this. So just some takeaway points. The lesson is comprehensive records are absolutely key. You need to keep them for the purposes of a compulsory acquisition because it is much easier for a valuer to conduct an accurate business valuation. And if you don't, it will potentially inhibit any compensation that you may be entitled to. And remember, your business is only has the value of what you can prove with documented evidence, and this is important in this context. Thank you.
Well, thank you, Natasha, for that. Obviously, yeah, a very interesting space, the COVID-19 world at the moment. And I'm here to just speak to you basically about family law, what the court's doing in relation to COVID-19 and how it's affected business valuations. So when you look at a family law property matter, I'm not going to speak about parenting today. They're obviously two separate issues the court deals with. In a property matter, obviously the court has a number of considerations they take into account when determining a just and equitable property settlement between two parties. But at the outset, the first thing that the parties need to do is determine what is in the property pool available for division. Now, in family law matters, it's sometimes very simple. It can include houses, bank accounts, shares. Obviously, superannuation is treated separately to normal property, using the quote, normal property being obviously the tangible assets of a relationship. But the further thing is obviously then businesses and trusts and the like that one or both parties have an interest in. And in a family law matter, it is becoming more and more prevalent now where business valuations are absolutely necessary, as that can be a major asset of the relationship. And especially with businesses where one party is likely to retain that asset, a valuation is essential. So obviously, as Mark, Tony and Natasha have said before me, a business valuation obviously is there to define a business. And what the family court will look at is the price that would be negotiated in an open and unrestricted market between a knowledgeable, willing, but not anxious buyer. Now, that last phrase, an anxious buyer, I'm not sure how we can really put that in context at the moment, given the current COVID-19 issues. But obviously what the court will have to do is reevaluate and look at a business valuation that has been determined prior to the COVID-19 issues starting. So what we're determining at the moment is, in the other issue, a lot of property matters especially aren't actually getting a lot of time before the court at the moment, because the court's obviously been on a reduced workload, as a number of people have been. It's obviously still open, but the court hasn't been able to obviously hear and determine as many property cases as they possibly have. So what we're proposing to clients at the moment is if you have had a business valuation done prior to COVID-19, and it is in your interest, obviously, if one party is retaining a business, maybe you don't want to get the business revalued at the moment because it might have substantially decreased in price, but obviously a pre-COVID-19 valuation may not be relevant anymore. So what you might need to look at is obviously having the business revalued now. Now, though, there are 5 main methods of valuing a business in the family court, which they've adopted. They are a capitalisation of future maintainable earnings. Now, obviously, at the moment, that's a very difficult circumstance to look at because we're not really sure what's going to happen in the future. As people have previously said, some businesses have been affected dramatically, others have been relatively unharmed. But obviously, moving forward, it's on a case-by-case basis. The value of net tangible assets, or on an ongoing concern basis, discounted cash flow, the notional realisation of assets, and the capitalisation of future maintainable dividends. Now, all the different ways of valuing a business, all are relevant to different businesses, but obviously at the moment it needs just to be taken on a case-by-case basis. So look, as far as property matters go, we're saying at the moment it's a great time to stop, take check, really get a lot of your ducks in a row, because we're not really certain as to what's going to happen next. Nobody really knows. And especially in family law property matters, the court still wants to address them as soon as possible and to get things moving. Obviously, in family law matters, sometimes there's a party who has, there's a significant distribution of power in the dynamics in the relationship. So matters still need to progress, but obviously what we're suggesting to clients is at the moment that it is worth getting a second valuation now, especially in light of the current COVID-19 issues, because you don't want a valuation where it's a business was once worth $2.5 million, and then by the time it goes to trial, it's worth $500,000, and the court then relies upon the $2.5 million valuation. So look, it's always important to keep the court updated. Now, a couple of the issues that we've previously had, obviously, with business valuations, are debts real debts? Now, that's especially important at the moment with obviously JobKeeper payments coming out of a lot of businesses, whether businesses have just been strategically, written down to obviously reduce income and generally to try and make sure that businesses can obtain JobKeeper payments, whether they're actually lower or not. So, but more in the family law space, we look at debts to family members, or family members or friends or relevant parties, and whether they are actually real debts. And that's something the court will look at to try and determine, obviously, whether A, it should be form part of the valuation, or B, it really should be taken into account at all. So that's something that people commonly will do is they think their marriage is going to end soon, so that they quickly run off to their accountant and make up all these fake debts to people, basically to reduce the value of their business. Now, the family law court has the power basically just to look through all of that and really take into account what they deem to be a real debt, shall we say, or something that is just a phony thing that has just been made up to take into account. Now, the other thing with a lot of businesses at the moment, especially with business valuations in the family court, is what happens when it's a largely cash business. Now, a lot of the time, businesses, rightly or wrongly, and I'm not saying people do this, and I've had clients who run large fruit businesses where they seem to have a lot of assets, but the business doesn't have any real valuation. Now, obviously, you will engage a business value to do a valuation, and the business might come back with a negative value or a really minimal value because the business has been largely dealing in cash over the years. Now, obviously, for one party to retain that business is going to be highly beneficial to them because they've got a financial resource that they can derive income from for their foreseeable future, but it's going to significantly disadvantage the other party. So that needs to be taken into account, obviously, in evaluation, but it is then difficult for the other person to claim, well, yes, he's had the benefit of all this cash over the years, because there could be substantial tax consequences involved in that as well. So it's something that needs to be weighed up when properly managing a family law matter, obviously, because you don't want them to have serious tax consequences in selling a business that may not have been doing everything by the book. And lastly, the other thing that's going to become more and more prevalent, we think, in the post-COVID-19 world is shadow valuations, and actually having and challenging business valuations at the moment, because we're not sure what's going to happen in the future. We're not sure if there'll be another spike and the curve will increase again, and we might all be back in the same position we were in a few months ago. We all hope not, but that's the issue that might likely be facing the family court at the moment, is having serious shadow valuations come in to try and clarify positions, clarify how valuers have come up with amounts for certain assets, so that we properly can protect our clients, and then also really protect moving forward that business asset so it isn't taken into account at the wrong level at the court. So look, just to sum up, basically, as far as business valuations in the family court go, is matters are still being heard. They are slightly delayed at the moment, but obviously moving forward, we expect that to return to normal sooner rather than later. But it is really important now more than ever to, if you've had a previous business valuation, that it be revalued, because otherwise a determination might be made in your matter where an asset's not worth what it was 6 months ago, that's for sure. So, and obviously if you do worth more, where you're not 100% comfortable with it, you can always propose to have a shadow valuation done as well, to obviously try and challenge or mitigate any issues. So that's about all from me, Andrew. So thank you.
Okay, thanks, Dylan and Natasha and Mark and Tony and Chris. We do have a few questions coming through, so I've unmuted the panel, so they'll be careful about shuffling papers and so forth. If we ask a question and you want to do a follow-up to it, or you want to get involved, please unmute yourself and turn your video on if you need to ask a follow-up to it. But I'll start from the top because I'm a very logical person, which is to Mark Bailey, and it's a question on how do you charge for forensic valuations?
Thanks, Andrew. I think that's in a compulsory acquisition sense, and we do treat that a little differently in terms of, we understand the situation with the government under the Act is required to reimburse reasonable expenses. So we provide an upfront fixed fee estimate, which most of the times we operate within that fee estimate. Sometimes things are not how they seem initially. So we get some financials first, prepare a fee estimate. Different law firms do it differently. I think Aitken partners submit our fee estimate to the government, and the fees approved, and then we prepare our opinion.
Thank you. Now, one to Natasha on the importance of having a lease in place when a business is being valued, particularly for compulsory acquisitions.
Yes, leases are very important for compulsory acquisition matters. You need to be able to evidence that you've got security of tenure to have a lengthy interest in for the purpose of assessing compensation. So you could there are some circumstances, obviously, where there's owner-operators and, you don't have a lease in place between yourself. We are able to claim compensation on behalf of those people, and we've certainly had a case in court on that particular matter, and that was Provins. I'm not sure if anyone's heard about it, but it was in relation to the East-West Link project. So that example, we had a landowner who owned the land, and then there was a business operating from that site as well. They didn't have a formal lease in place. They were paying rent. So we were able to evidence that there was an interest, and we needed to evidence from the director's point of view that they would not have terminated the relationship between the two of them. But for the purpose of assessing compensation, is better if you've got a lease in place.
Another one for you, Natasha, which will be a very quick answer. Does the government compensate clients for legal counsel fees and other valuers' fees?
Yes. And as Mark just said, the only caveat to that is that they need to be reasonably and necessarily incurred. And as long as we can evidence to the government or the acquiring authority, whoever it is that's acquired the land and the claim is being made on behalf of that, the fees have been reasonably and necessarily incurred, then yes, they are.
Thank you. Now, a slightly longer question, which will involve anybody who wants to get involved. So it's a question on the valuation of businesses such as cafes, bars, or restaurants where ongoing trading is impacted by restrictive trading conditions post-COVID-19. So instead of basing the valuation on the historical performance pre-COVID-19, is there a suggestion that the valuer will seek the directors to provide a forecast profit and loss going forward to establish a value? And is there a value of the business if the business cannot be profitable in the new environment? Whew, got there.
Well, I'll start on that one. Yes, obviously the emphasis will be on the trading performance of the business up until COVID, and then post the valuation date, let's say. So yes, you need to look at the current operating performance of the business. If the business is not profitable, then it will be valued based on its net asset basis, and it could be that it's even on a liquidation basis. So, but if the business is profitable, then assuming that it's generating a reasonable rate of return, you could value that there is some goodwill in the business. But it depends. I mean, every situation will be different, and it needs to be looked at on its merits.
Again, it's kind of similar topic, I suppose, but we've got a question on somebody who is in the allied health business, so effectively running a clinic, and it says, how much has the value of the average business dropped due to COVID-19, and do you take revenue drop / profit decline into your calculations?
Yes, you do. You do take a decline into account, but you also have to try and assess if it's a temporary decline and what remedial strategies do management have in place. Normal, good management will look at a drop in their revenue and drop in profitability and try and turn the business around. Now, if they are saying that the drop in revenue, drop in profit is permanent, likely to be permanent, well, then that will have a significant impact on value. But if there are measures in place to make that drop is temporary, then obviously the valuation will not be as affected as what one might think.
Thanks. And the one last one is, does intangible property include goodwill of a business?
Yes. Yeah. And Andrew, I think an important thing for everyone to understand is value is a long-term consideration in terms of the market value of a business. So if there's a short-term hit to profit, well, that might cause some adjustment to the market value. For example, if the forecast that was that earnings would be, say, 100,000 less over the next couple of months than it would have otherwise been, then there'll be some adjustment to the value of the business. So the value is still, it's a long-term consideration, because it's not just about the next month or 6 months or 12 months. It's long-term. We're looking 5, 10 years. How much money is this business going to make over the next 5 to 10 years? That's where, it's always a hypothetical situation. It's never certain how much money is the business going to make into the future. If there's a 1 month, 3 month, 6 month, even 12 month impact to earnings, yes, there's an adjustment. For some businesses, that will be catastrophic. For other businesses, it'll just be an adjustment to the value, the long-term value.
It goes back to one of the original things I said, and that is, are we being engaged to value the business, or are we being engaged to determine what price it can sell for? And they're two different things. It's like if you turn up to an auction, or if your property is put up for sale at an auction and no one turns up, does that mean that the business is not worth anything, or that the property is not worth anything? The answer is obviously not. It just means that in the market at that time, there were no bidders. So we're looking at the same thing. We're being asked to value businesses, not necessarily determine what price they can sell for. And Warren Buffett is famous for saying that price is what you pay, but value is what you get. And there are people out there all the time looking for bargains, which means that they're paying a price lower than what a business is really worth. And then there are people that overpay for businesses for one reason or another. So very important to understand. And as I think on Mark's first slide, there's a fund in the US that's been set up. It's got $9.3 billion in cash, I think the number was, waiting to buy businesses. So they're looking to be opportunistic and buy businesses that for a price which is going to be probably less than value.
Cool. Well, thanks for that, Mark, Tony, and Natasha, Dylan, Chris. Interesting topic, but my takeaway in the most self-serving manner that I could possibly say is that if you want to extract the true value or the full value of your business, you actually do need the best advisors you can find. And I think that's where your lawyers and accountants can come into play and provide a true value service to you. In closing, we don't have another topic lined up at the moment. Normally we do. I'm quite open to anybody asking me questions via email, and it's aclark@aitken.com.au. I will be sending out an email later on today with all the contacts and a link to this video on YouTube. We are happy to hear from anybody about the topics they want covered, or if they want to join with us in presenting a topic. So please stay open to that concept. The beauty of webinars is that we can do them fairly quickly. So we only need like a week or two's notice to start a conference. So thank you to all you for joining, and thank you to our panelists. Thank you.
Thank you, everyone.
Thank you.
Thank you.